Creating a New York last will and testament is not necessarily a daunting legal task that requires hiring an expensive lawyer. In fact, wills are rather simple and straightforward documents to make in most cases. In this video, we'll go over the importance of wills and what happens when one isn't made, what's included in wills, legal requirements in New York, and how and where to create an official will. Let's begin by looking at wills and their importance. A last will and testament, simply known as a will, allows an individual to designate instructions on how they would like the distribution of their property and assets carried out after death. By naming their beneficiaries, usually spouses, children, and blood relatives, the maker of the will can select the individuals who shall inherit all or a portion of their estate. Now, what occurs if no will is left? A person who passes away without a will in New York loses full control of who inherits their property. Instead, state succession laws dictate how the deceased assets are handled. The deceased spouse, children, or blood relatives may inherit the property through a set formula, but it differs from case to case. Leaving one's property in the hands of the state can cause loved ones to contest the decisions made by the courts when distributing the estate, which can lead to lengthy court trials. It is recommended for all adults to have a will, especially those who are elderly or facing life-threatening conditions. Making a clear will can make all of the difference in ensuring loved ones receive their inheritance, and what's best, wills can be created without an expensive attorney required. A person of sound mind can draft a will in New York with the following information on the document: their full name and residing address, the information of their personal representative, also known as the executor, who will distribute the assets accordingly, the names of all beneficiaries, and a thorough list of the property each shall receive, any additional terms and conditions, and the signatures of the testator and 2 witness signatures. And finally, let's review a few legal requirements in New York. Last will and testaments in New York must be signed by the person to whom the will belongs, known as the testator, in the presence of 2 or more trusted and competent witnesses. Though optional, it is recommended that both witnesses be disinterested parties. Disinterested parties are individuals who do not stand to personally benefit from the will or receive a share of the testator's estate. Once all parties have signed, the document will be legally binding and executed in the eyes of the state law. Several copies can be made and given to trusted individuals for safekeeping. We're eForms, the biggest database of legal documents. We have created state-specific last will and testament templates specifically designed for New York that are quick and easy to fill out. Our software generates an official document after you select your desired will instructions and name all of your beneficiaries. Click on the link below to begin creating your will. And don't forget to like and subscribe for more daily videos.